Moving on to item 11, condemnation, resolution 2017-53. I'll move the item.
Second.
Motion and a second. Supervisor Miller.
Madam Chair, my objections to the way these condemnations are done, I talked about it in the last meeting and previous meetings, so my objection still stands.
Supervisor Christie.
I did speak to one of the major property holders of this resolution, and according to the property holder, that it is proceeding exactly as has been negotiated with the county. I would like basically just a explanation of why the condemnation and eminent domain process has to be implemented, or at least authorized. And then under Exhibit A, it does show the specific parcels that are being negotiated or have been negotiated for purchase by the county. But it certainly must be misleading, in fact, because the shaded areas extend much further away from where the proposed loop pathway is being constructed. So I just like assurances that the properties that are being negotiated with the county meet with the owner's approval, and that it's not going to be a massive land grab for other shaded areas that are on the exhibit.
Shaded or shady? No, never mind. Mr. Huckleberry.
Yes, Madam Chair and Supervisor Christie. The exhibit, and we've addressed this before, and what's missing from this exhibit, and for example, if you look at parcel 5, the reason the whole thing is shaded because it's one owner, even though we don't even come close to touching the north piece of that one owner. And if you then look at the resolution, it says for the purpose of constructing the loop is a 16-foot path, and so the condemnation, if it ever becomes required, will take 16 feet. Basically connecting at the top where you see it kind of end and then coming down to the bottom. And what we have done is we've negotiated with most all of these property owners, and we believe most of them are all in agreement with regard to the acquisition. It can shift a little bit one way or the other when it's in the field, because the staff will work with the property owners to minimize the impacts and perhaps put it in locations where they can't see it, which is one of the objectives. And the condemnation also is typically an advantage to the property owner, and usually the property owner wants us to adopt this resolution because their tax consequences are vastly different in an acquisition, in a threat of condemnation, in a condemnation action that has been authorized but not filed.
Madam Chair, so there would be no conflict with actually negotiating with the property owner for a cash purchase versus the condemnation appliance. It just seems like you're going ahead and buying the property and condemning it at the same time.
Madam Chair and Supervisor Christie, this simply authorizes condemnation. It says that it could be issued if it's required. In all these particular owners, we do not believe it will be required. It's an issue of last resort. In almost all cases, we don't file condemnation, but the property owners typically want us to have the threat of condemnation so they get the federal tax advantage over the action of the board to take the property via condemnation.
It's to the owner's advantage to do it this way,
I
essentially.
had some property at one time, and I perhaps should have pursued condemnation.
Maybe.
Madam Chair, and you get a much longer reinvestment period where you don't have to pay taxes on the proceeds, a number of options that are beneficial to the private property owner.
So it's still, again, underlying, Madam Chair, that the property owners are satisfied with the negotiations and the purchase prices, and that you don't see the actual implementation of taking their property.
Madam Chair and Supervisor Christie, at this point in time, everyone appears to be fine. I cannot guarantee that somebody will not change their mind at the last moment.
Thank you.
All right. Any further discussion? Any objections?
I object.
One objection, no further objections. Motion carries 4-1. Moving on to item 19.